morning, everyone. My name is Yvonne Bendinger-Rothschild. I'm the Executive Director of the European American Chamber of Commerce, New York office. And I would like to welcome you to today's webinar, Navigating the Challenges of U.S. Visa Renewals and Their Effect on Hiring. Our panel will provide a high-level overview of the renewal process across several visa categories. And even more importantly, what the renewal procedures, some of them new, some of them never been seen before, will mean for your workforce strategy, operational planning, and risk management. We explore the timelines, requirements, strategic considerations, and we'll try to enable you to keep talent in lawful status, and whether they're renewing from the US or from overseas, and also highlight some of the policy shifts and challenges that are emerging across various visa categories. I'm joined by Kensani Matebuela. I'm an attorney at Laura Devine Immigration. Kensani is an attorney with the US team in the New York office. She assists with a wide range of non-immigrant and immigrant cases, with a particular focus on EB1, O1, and L1 petitions. I think we will be hearing a lot about the L1 petitions going forward. And we also have Dina Merlin with us. She's a partner at Travis Page Jump and an employment lawyer. Her practice areas include employment and labor, corporate, IP, and as well as technology and privacy. So let's dive right into the conversation. Kensani, could you give us a broad overview of how we define visa renewal versus status extension?
Absolutely. So visa renewals and status extensions are different, but sometimes related processes in U.S. immigration. Overall, a visa renewal is when you need a new visa stamp to enter the US, right? And so usually when we speak about the H, and the O visa and the O visa, you already have an approval, a petition approval, and then you attend a US embassy interview at a consulate abroad for an interview. You leave your passport with the embassy. Depending on where you are, it can take a different amount of days to get your passport back with the visa stamp in the UK at 7 to 10 business days. And then you're able to enter the US in your status. Versus your status extensions relate to when you need to stay longer in the US in your current immigration status. And so that would be, you would be inside the US, and usually you would be filing an extension through USCIS, so that you may be permitted to legally stay longer, so that you may remain in the US to work. And so two different but related things. One has to do with being able to continue staying in the US for an extended period of time, versus the visa renewal is once you have left the US and your visa has expired, getting a new visa in order to enter the US.
Yeah, I mean, major distinction, because a lot of employees do not understand, I mean, even employers, I would think, do not quite understand the fine yet distinct difference between the two of them. What does a little bit more broadly, and to give people a better sense of what a renewal process looks like, and what are some of the key steps are that employers and employees need to take to initiate, get through it, find their way. And the thing is, for background, we're asking this question because many of our members are already employing foreign nationals. They have a visa, they're perfectly fine with a visa they started out with, but now, you know, we may be running into challenges, and then you know, this is in a nutshell why we have this scheduled this webinar. But Kensani, back to you on the you know, what does the process look like, to give our audience a better understanding of that?
Sure. So if the employee is based in the US and needs to extend their status, it looks like the employer filing, it's called a Form I-129. So filing the Form I-129 with USCIS, typically that can take about 2 to 6 months for processing, depending on the visa type. However, premium processing is an option. So if you pay right now, the premium processing fee is $2,805. So if you pay the premium processing fee, USCIS will take adjudicative action on the case within 15 business days. At which case, then their status has been extended, and they can work while the extension is pending, up to 240 days. So that's what it looks like when they're in the US. If they have left the US, but they have an approved petition and it is more about getting a new visa stamp, then it is about scheduling an appointment at a US embassy or consulate abroad, which is based on interview availability, so that it differs based on each consulate and also the visa type. And with that process, the employee would complete the online DS-160 application. They would attend their interview. And as I said, for example, in the UK, it would take about 7 to 10 business days for the embassy to then issue the new visa stamp in their passport so that they may re-enter.
Yeah, that sounds pretty straightforward. With that said, from an employer viewpoint, you have somebody whose visa is renewing in, let's say, 6 months. In the past, it was a quick 1 month renewal process. Now you need to plan a little bit longer. What happens if the visa doesn't get renewed? Are you going to put somebody on a project? Dina, what are you seeing when you're talking to employers? Is this coming up? Is this a topic? What are you seeing from your viewpoint?
Yes. Employers are aware that things are taking longer. That the paperwork seems to be held to greater scrutiny. So one of the things we're seeing is how important expectations management is on recruitment and meeting your business needs, and also your communications with your internal stakeholders and your employees or potential hires. It spares a lot of frustration if you speak with your immigration attorney, get a sense of what the timing might be, what the range is, and be very, very transparent about that, and start early, start ahead of when you might think you need to. There's an awful lot of uncertainty.
I mean, I'm thinking, some of the visas that were granted, we talked about it a second ago. Ukrainians fleeing the war were giving work permits to work in the United States. There was a story in the Times that some companies are now facing the loss of 20 to 25 employees all at once, a small business or medium-sized business, I would say. And they're now dealing with how are we going to replace them? Can we keep them? When your chief engineer is on a visa, you're thinking twice about what's your planning? I mean,
yeah, no, exactly. It's very hard. You need contingency plans. Your plan A has a plan B, and behind that is a plan C these days.
I mean, but don't you also run into issues when so you have let's stick with this engineer on a visa. I mean, it's somebody mission critical to the company. How are you dealing with them when throughout the process when they need to get their visa renewed? Are you interviewing for possible replacement contacts, or how are you dealing with this from a business perspective?
Well, one of the things I see some of our clients doing, especially when there are bumps in the road, they're trying to be nimble the same way you would if a U.S. citizen employee needed to go out on reasonable accommodations. They have parental leave or disability leave. You have short-term measures But then eventually you might recognize, oh, this person may not be coming back. And then you start to explore the longer term measures for continuity. We're also seeing, and this is having an impact on the process and on renewals. We are seeing a huge wave of clients coming to our door because they need to engage in large-scale reductions of force. There's a lot of layoffs going on and a lot of restructuring. Some of our clients are large nonprofits whose federal grants have dried up and gone away. Or we have companies whose business is based on the existence of large federal programs that are no longer being funded. So they need to pivot, they need to restructure. They're reducing their headcount and focusing on different aspects of their business. And in the real world, with the one that I'm living in right now, this is having huge impact. I'm dealing with a client right now that's closing down its New York location and consolidating its remaining employees at its location in another state. What about its employees that are on an H-1B visa, which is location specific? Speed dial, immigration lawyer. Or in another example, a restructuring where the company's business lines are constricting and the employees who are able to hold on to their jobs may have to pivot into a different role. Again, what's the impact on your renewal? Your job description would be different. Is it enough of a material change that you should actually file an amendment ahead of your renewal that's coming up? Again, speed dial, immigration lawyer. These are the sort of issues we're seeing with this very volatile labor market that we're in right now.
Yeah, you're raising two really common and important issues. Kansani, let's give a brief overview of some of the most common visas that we're dealing with. So we're talking H-1Bs for specialty occupation. That's why I'm here. L1 for intercompany transferees, and then O1s and TNs.
Yes, absolutely.
Start with the H-1B.
Will do. So H-1Bs, yes, absolutely, for specialty occupations. They tend to be for highly skilled professionals in fields like tech, engineering, finance, and healthcare. To be eligible, the employee must have a bachelor's degree or higher for the specialty field in which they will be working. As you touched on earlier on, the H-1B it functions as a lottery. So there is an annual lottery each year, and there is a cap. The lottery is specifically because there is a cap on the number of petitions that USCIS may approve each year at 65,000, with an additional 20,000 visas reserved for those with US advanced degrees. And that is apart from cap exempt H-1Bs, which is particularly for universities and nonprofits. But within the corporate space, you're looking at the H-1B usually for individuals who have just graduated. They may have come to the US on an F1 student visa and then gotten some experience at your company on OPT, optional practical training, which gives them time to get experience in their field without a visa for a certain amount of time, usually 1 year, unless they are in STEM, in which case they can have up to 3 years of OPT. But the way the lottery works is it begins in March of each year for about 2 weeks. It is a computerized lottery system, and so the selection rate is quite dismally low. It's about 20 to 30%. And the employer must register the employee in the lottery, and the employee must be selected in the lottery before the employer may go on to actually file a petition for them. And then, if it is approved, then the employee can start work on October 1st. So it is not the most convenient of visas. It does give the employee a 3-year visa, which can be extended for up to 6 years. So 3 years and can be extended up to 6 years. And the employee is able to port a cap H-1B to another employer, if they wish to do so. But that is the H-1B system. And, I'm sure Dina can attest, for employers, it can be very aggravating because if you want a particular foreign national to start work with your company, you don't want to have to wait till March to enter them in the lottery, and then you don't want to have to wait until October 1st for them to start. Okay.
I mean, I can speak from my own experience. That is quite a wait. I mean, that's not new, but I mean, first you need to find the person. They need to be available. They need to, I mean, with a job in New York, it's probably easier to keep them, you know, like interested. But if they find another job halfway through, you invested all this time, you went through the lottery process, you didn't get anybody else in the lottery process. They come out of the lottery and they decide to take a job in Paris.
Yeah, it is aggravating on both sides, absolutely. However, it does happen each year, and so if the employee has an undergraduate degree in the field that they're looking to work in, it is definitely worth registering them. It's worth, you know, the chance of selection. I'll move on to the L1 visa for intracompany employees, so executives, managers, and employees with specialized knowledge. Particularly the specialized knowledge employee, L1B, may offer a solution for those who are not selected in the H1B category. So for intracompany transfers, there must be an operating company outside of the US, right? And the employee must have worked abroad outside of the US for at least 1 year within the last 3 years before the company wishes to transfer them to the US. And the entities, the entity abroad and the entity in the US, must have a qualifying relationship. So they may be a foreign affiliate or a subsidiary or a parent. And then the actual employee, as I said, they may either be an executive or manager, in which case they would qualify for an L1A visa, which is a 3-year visa that may be extended up to 7 years, a max of 7 years. Or they may be a specialized knowledge employee. And so those employees must have specialized knowledge of the company and of the industry. And that visa is a 3-year visa, can be extended up to 5 years. So for individuals who are not selected in the H1B, I understanding it's not the most convenient of solutions, but there is the option if the company has an entity abroad to send the employee abroad for 1 year and then to transfer them to the US on an L1B or an L1A. Yeah.
An interesting setup. If you think about it, I mean, you would send, if you're starting a company in the US, and maybe that's only if you're starting a company in the US, and I'm thinking of one particular member of ours who did that. They sent their best guy, in this case, to start the company in the US. So they would take the person who gets the shortest visa. In your case, they only get a visa for, you know, the specialty occupation or the expert who knows the market, knows the product and everything. They get the shortest visa, the five years, versus a general manager who you know, is eligible for a 6-year visa.
Up to a 7-year visa. And you raise a good point. You raise a good point because the L1 visa also presents what is called a new office L1. So that is if the company is established abroad, but they still need to set up an office in the US, then we can get an employee who has one of these roles, managerial, executive, or specialized knowledge, a 1-year visa initially to come and actually set up the business, and then we can extend it. Yes, and so that is the intracompany transferee visas, which I must say for L1As and executives, for managers and executives, there is a green card route. It's called the EBC route. And so for those who are managers or executives, the L1A is quite strategic for them because it means that they may have the opportunity to stay in the US permanently. Okay, and then let's move on to the O1 visa. So these are for individuals with extraordinary ability in sciences, arts, business, education, or athletics. Generally speaking, we must show that they have national or international acclaim. There are particular categories that you must show that the employee meets at least 3 of the criteria. And in the keeping time in mind, I won't go through each of them, but I'll just highlight. It'd be things like that they've received an award in their field or awards, that they have press. So press about them and the work that they've done anywhere in the world. And also if they've made a major contribution in their field. That is the kind of thing that USCIS is looking for when it comes to an O1. We do many O1s for athletes and artists, but also for businessmen and scientists. Again, it usually is a visa that isn't for recent graduates, you know. It is a visa for those who really have had quite a robust career, generally speaking. And they must also show that they have an itinerary. So they have, not only do they have extraordinary ability in their field, but also they're coming to the US to do work in their field. It is a 3-year visa, and it can be extended. And as long as you show that the O1 applicant continues to have work lined up in the US. Okay. All right, then, yes, there's the TN visa, and this is for Canadian and Mexican foreign nationals based on the USMCA, or formerly NAFTA. And it allows Canadians and Mexican citizens to come to the US to work in specific professional roles. It must be a profession that is listed. And so it covers engineers, accountants, scientists, etc. There is no annual limit. So, you know, this is also a great solution for those who otherwise would have to enter the H-1B lottery. If they are Canadian or Mexican foreign nationals, you can just apply for the TN. And with basically TNs, they can apply at the border. So it's an easier process overall. And then I'll just mention one visa type, E2. I promise I will stop talking, but the E2 visa is based on treaties that the US has with particular countries. And it basically is based on if a company is willing to invest in the US, and the company is majority owned by treaty nationals, they can invest in the US and then send employees of that same nationality to the US on 5-year visas. And that process is done at embassies abroad. It isn't a USCIS petition. So initially, registering a company as an investor takes about 9 months. But then after the company has been registered, then each employee only has to book an interview, an embassy interview based on availability. They go have their interview and then they get their visa. So on the back end, it presents quicker processing times.
But the investment needs to be substantial. How do you define substantial? Because there's a lot of span between substantial and substantial.
It's a great question. There is no hard line. There is no minimum threshold, but we recommend making an investment of at least $100,000. And that investment must be spent. It can't be prospective. It needs to be money that has been spent, and that can be on legal fees. It can be on fees to incorporate the company. Even usually they don't accept operating fees, like operating costs such as salaries. It is more so startup costs, such as payments or money one would spend on equipment to get the company started.
Okay, I'm just taking some notes here. Fascinating. So what in the framework of these 4 visa categories are the new challenges that you're seeing with the renewals?
So with renewals, you know, there is a deferral memo, but it isn't usually applied, meaning that USCIS will just defer to their previous adjudication. What we're seeing is that each filing, even renewals, have to be strong filings in and of themselves, because they are reassessing if the applicant really does qualify for the visa type, you know, and so one wants to present as much evidence as possible because of the highest scrutiny. So simply because there is high scrutiny, employees should not take it for granted that just because an employee was approved initially, that their renewal will be approved, you know, automatically.
But isn't that kind of good thinking? Because you wanted to make sure that, you know, this person really, really, really qualifies for that visa. Or why do we take offense with that extra scrutiny? Is it really often the case? I mean, it's maybe too early to say, but is it really happening all that often that, you know, that H-1B that got through is now not getting through anymore?
I would say, no. Thankfully, in our practice, we haven't seen increased denials, but we have seen increased RFEs. So an RFE is when USCIS issues a request for further evidence. So that is to say that you filed the petition, you've hopefully paid for premium processing, so they've adjudicated the case in 15 business days, but they come back with, instead of a straight approval, they say, we don't really believe that this employee, that their role abroad was managerial, or that their role in the US will be managerial, or of an executive nature. And then it presents you with an opportunity to then file a response presenting additional evidence. So we've seen increased RFEs because of the increased scrutiny, which just means on the employer side that it will take longer than anticipated. And that is why we can't repeat it enough, but to say, even with renewals, start well in advance.
And it's not only that, and here we come back to you, Dina. It's the whole, compliance part of this, the audits, documentation hurdles, all the paperwork. What are you telling employers, how to, I guess, get their ducks in a row to make this as smooth a process as possible?
Yes, start early, partner with good immigration consultants or attorneys as needed, train your people, keep good records. And as we are all being buffeted by the winds of change right now, so very much in the business community, I used before the example of a company that's restructuring that might affect the job description. So now it's no longer what it was when you first this employee, and now you have to do a renewal. You have to make sure you've stayed on top of changes, not only in the job, but salary thresholds. We're seeing companies having to change what they're paying their people in order to preserve as many jobs as possible. There might be doing some cuts. How does that affect your renewal? How does that affect your eligibility of your employee? Also, stay on top of the personal lives of your employees. We've certainly seen with people who are here legally but having difficulty with reentry, some of the advice that they are receiving is, hey, if you're already got a green card and you're married and you've been here and you're eligible for citizenship but you haven't applied yet, maybe now's a good time to apply. Or maybe there's been other changes in the employee's life, their marital status, their health, other things that might have bearing on their visa renewals. So as an employer, you want to stay on top of not only how the job itself has changed, the salary has changed, or changes in the personal life of your employee that all might have bearing when it's time to address the renewal. You want to be ahead of that.
So, yeah, of course, a U.S. citizen will not be denied re-entry into the United States. That's paradoxical. But so what you're seeing is green card holders, and what's I guess green card would be the next step down, being denied because of health issues.
No, what I'm saying is, just as an employer, you need to be familiar with changes in your employee's life and changes in the job that you have them doing and the duties, the location, the salary, anything that might then have impact when it's time to renew. Some of the changes might be material enough that an amendment or other paperwork should have been filed ahead of your renewal. Again, we keep Immigration Counsel on speed dial for these questions. But as an employer, you don't want to kind of wait to the last minute and then be broadsided by changes that you weren't ahead of.
Yeah. Kansani, yeah, what could those changes be, if you could?
Absolutely. So yes, to Dina's point, if there are any material changes to the petition, then an amendment should be filed. What that would look like is, for example, if the nature of the role has changed, so if someone comes over as an O1B, but then is promoted and now has a managerial role, there should be an amendment for an O1A, right? Because now they would qualify as an O1A instead of an O1B. So there is particular focus, especially with O1s, on the job, on the role, on the job duties, and making sure that they are in line with the visa type. For L1As particularly, so managers and executives, yes, USCIS likes to see multi-level management. So not just that the employee has direct reports, but they have indirect reports, right? And so we provide organizational charts on both sides. But also when it comes to the job description, they don't just want to see an overview of what the person does. They want to know not just what they do, but how they do it, which departments they delegate to and oversee, right? So in the way the job description is framed, we pay special attention to making sure and highlighting the managerial or the executive nature of the role, or inversely, on the L1B side, highlighting the technical knowledge that the employee has to emphasize their specialized knowledge.
Yeah, and you can do this via all kind of documentation. We already discussed the job description that you adjust, or make it a formal letter for a promotion, or and then add in that letter, what the extra responsibilities are, etc. Okay. Taking all of this, I mean, it seems like, and that's a question for Dina, that the visa status has been, I mean, and maybe I'm naive in that assessment. I mean, when I was under an H-1B, I just kind of like kept doing my thing. I mean, I was in the same or very similar role for the entire extension, so it was rather boring H-1B, but I was just kind of like going about my thing, and that was great. But it sounds like that this has become a little bit more strategic, or there's a little bit more strategy and thinking through and all of that required from the employer. Dina, what are you seeing in the market, so to say?
Let me make sure I follow in terms of whether a job is static or evolving. Yes, yes. And I think that's my point, is so much of our practice right now is helping. It's almost, crisis management for so many of these companies that are really challenged right now. And it has direct impact on what people do and what they are paid, and changes within the structure that is challenging for any employee, but it has particular challenge for foreign nationals.
Yeah.
Where it is creating inconsistencies within the universe of paperwork that will need to be addressed.
But does that really help? I mean, we want foreign companies to expand their businesses. Foreign companies, in many cases, come with a couple of foreign employees, or at least formerly foreign, now locals. How does that make sense in one and the other to get to a goal, to achieve a goal?
Well, my main focus with this point is that it's not really static. In fact, right now, it's particularly volatile. And so employers just need to be aware of how that will impact the renewals when it's time to renew, and the heightened importance of working closely with your immigration attorney to make sure that you are filing amendments at the appropriate time and not waiting to the last minute and then discovering you have a problem. Because it no longer fits, that we do need to make a change, or, the individual is not really eligible anymore. There's something in the way the role is, the duties have materially changed, or the salary thresholds are no longer met. You just don't want to be broadsided by these things. Many of our clients are being a bit reactionary right now. They're dealing with the difficulty. We need to bring our numbers, our budget needs to be aligned. We need to make cuts. And they're very focused, some of them, on just survival, and they're not really thinking about the ramifications this has on a renewal that you're going to be looking at 4 months from now.
Yeah,
That you're going to start working on. So.
And the thing is also, I mean, I always say, when you need immigration advice, hire an immigration attorney and not just any attorney.
Yes.
Because once you filled out the
specialized.
paperwork, whatever you send in is written in stone. Nothing you can do to change it afterwards.
No, and it's a very specialized area. That's why I know I've said it like 5 times so far in this webinar. Speed dial to Immigration Counsel, because it is a very, very specialized area of law, and it is at a time of change right now. There's been a lot of change with the new administration and the focus of the policies. At the same time, there's a lot of economic upheaval, and there's a lot of people moving from one company to another as they're being laid off and looking for new work. So, put all of that together, it's a particularly challenging time, and the need for really well-qualified immigration counsel has never been higher.
Yeah. Speaking of immigration being a moving target or immigration policy, let's talk about 2 updates that managers need to know about. First, what is the US CIS deference memo? And second, what's the status of interview waivers? These are both questions for Kansani.
Sure.
What do we
Okay.
need to know?
So the deferral memo, it refers to a USCIS policy guidance that was issued in April 2021, which seeks to restore the longstanding practice that I mentioned earlier on of deferring to prior approvals when adjudicating non-immigrant extensions or renewals, unless, and there's a caveat, if there has been a material change or a clear error. So if there's a clear error and it shouldn't have been approved previously, or if there's a material change, such as the nature of the role or the corporate structure of the company has changed, right? They can re-look at the renewal as a fresh petition. But as I said previously, it is always best to proceed with caution. We always file our renewals as if they are initial petitions. You want to provide as much evidence as possible and not assume that they will apply the deference memo or and that they will approve an extension simply because it was initially approved.
Yeah.
And then
interview waiver?
Yes, when it comes to the interview waiver program, it allows certain visa applicants to skip the in-person consular interview. It typically only applies when renewing a visa in the same category. And simply put, it just waives the in-person interview. The State Department, it has extended the authority of consular officers to waive interviews through December of 2025. So for individuals who, whichever work visa they're on, for example, if they go to it, when they are seeking to extend their visa, they may not have to be interviewed. But again, it is at the discretion of consular officers. And so they may still be interviewed. It's best we always prepare our clients for interviews just in case they are interviewed in a way.
Yeah, I mean, I remembered when I just renewed my green card, I did it actually electronically. I didn't even come in. Last time I needed to come in for fingerprints, and which was a pleasant experience. I went to One Liberty or whatever it was, Bessie or whatever the street is. And it was like zip, zip, in, out, and getting your fingerprints redone. This time I didn't even have to come for that. I just filed everything electronically, and I think I got it. Turnaround was 2 weeks or something. It was amazing.
Yeah. Fantastic. Yes, that is, ideal. The ideal situation is that the interview is waived if you've already been approved for the particular visa type, and it's just an extension of the same visa type, right? It really does help everyone involved for them to defer and to waive the interview.
I mean, they're trying to scale down. I mean, there have been layoffs at the State Department, so that means we have less consular officers. So that's also not helping with the visa renewals. Now, is that still a major problem?
Yes, so it's partly the reason why we've seen prolonged administrative processing. There simply are not as many employees as before. And so when you couple that with the additional scrutiny and the additional RFEs, it's just a slower process overall. Which is why we can't emphasize enough for our clients and for employers to get immigration advice frequently and well in advance of when they need an employee to start, or well in advance of whenever an employee's visa will be expiring or their status will end.
Consulate,
Yeah.
how much in advance are you advising clients to start the process?
So it depends on the particular visa type, but I would say a good rule of thumb is at least 6 months before, at least for them to get the information and for us to discuss the particular visa type they are seeking, so that we can give them realistic timelines, current timelines, because the processing times do change. And so we constantly want to give them the most up-to-date processing times. But for example, for E2 applications where you don't have to file with USCIS and it's just based on interview availability at a consulate abroad, it would just depend on that availability for that visa type. So for example, for the E2, it should be about 6 weeks out, but for B1, B2, it could take several months.
But
yes.
I mean, but there we're back to Dina's initial comment. What if you're decreasing your workforce? How does that all kind of go together? I mean, it seems like a game of Tetris that you're playing here with your people. I mean, and I don't want to sound so casual, but I mean, it's complex. You need to have on one side, you need to have a calendar for all of the visa renewals coming due. Then, am I laying anybody off? Who could it be? And then, I mean.
And I'll raise another point, which we're seeing under this administration, where traditionally, we do a great deal of work at our firm in the area of discrimination. We're very often in front of the Equal Employment Opportunity Commission with employment discrimination claims. And where national origin has been concerned for the bulk of my multi-decade practice, it's been about whether there has been discrimination on the basis of national origin by Americans against the foreign national. And right now, that's been really turned around. There's a huge focus in the enforcement efforts of this Department of Justice on whether the Americans are being discriminated against in favor of the people whose national origin or citizenship differs. And in the context of visas and work permits too, I would think there is likely, and you tell me if you're seeing this, Constani, in your practice, similarly, a greater scrutiny on whether are we losing American jobs to foreign nationals, and whether that has any bearing on this process. I mean, I don't know if you're seeing that or not. We certainly are within the context of charges of discrimination that are being filed and enforced.
Yeah, I think it touches on kind of the prevailing wage, which you mentioned previously. There are safeguards to make sure that employers are not hiring foreign nationals at a lower rate than they would American employees. So for example, when you speak about the H-1B, a part of the process is filing a labor condition application, or an LCA, with the Department of Labor. And a part of it is the employer must agree to paying the employee the prevailing wage as of October 1st. So we've been through the process. They were selected in the lottery, you filed the petition. Starting October 1st, they need to pay that employee the prevailing wage, which is determined by their location, but it's also determined by their specific role and their level of experience. So what we have found is that employers may not realize that the prevailing wage is much higher than what they thought it was for a particular employee. It may look like a student on an F1 visa has worked for them on OPT and has gained experience, and they really love this employee who's proven themselves. Luckily, the employee is selected in the H-1B, and then the employer realizes that the prevailing wage is much higher than they had anticipated. So that is the type of thing that an immigration attorney could advise the employer beforehand, so that, you know, they are aware of it in the lead up to their H-1B beginning.
Yeah, but that was always the case. I remember that was an issue when I filed my H-1B, that you had to have an equivalent, you had to have a search for an American who could have, you know, taken the job. I almost said replace me, but taken the job instead of me. And then you needed to make sure that I'm on the same wage level and then I'm not coming in as cheap labor. You know, before we have another 15 minutes left. Give us, you know, some strategic guidance for employers. What are some of the best practices for a smooth renewal experience, both from the employer side and from the foreign national side?
Okay, so start well in advance. As I said, a rule of thumb would be at over 6 months in advance. And the point of that would be to discuss all of the visa options that are available for the employee, you know, such as the H-1B, but if the H-1B doesn't work, then there's the L-1B route. We're also discussing the O-1. We pride ourselves on helping all of our clients to know all of their options early on. And also having a sense of what the current processing times are at you know, at that time. For H-1Bs, you know, we just brought it up, but prevailing wages, make sure that you are aware of what the prevailing wage is for the employees that you're seeking to hire, and how that can be different based on the office where the employee is located. Prevailing wage in New York is very different from the prevailing wage in Texas or whatever other state.
What about on that note, because Dina also mentioned that earlier, what about remote work? So I hire somebody in Ohio, and they're really supporting the New York office. Are there any changes there, or?
So for the LCA, we must list every site where the employee will work, including their remote work address. So that would be usually their home address. And we look at the prevailing wage for each location. And so the prevailing wage that would be controlling would be the highest one. So if they're going to come into the New York, let's say they are in Ohio, but they're going to be coming to the No. office, right? Then the prevailing wage in New York would apply, because they will be working.
What if they never come to New York?
No,
I'm just asking. I mean, I don't know. I mean, it's
yeah.
I mean, I'm in a way an employer, you know. I mean, not in a way.
Yes.
I am an employer.
Yes. Oh, well, that is something that we would ask the employer, truthfully, based on this role, where will they be working? And so if they won't be working in New York, fine. We just have to list every address where they will be working.
Okay.
Yeah.
Interesting.
Yeah.
And job descriptions. Let's drill into that a little bit more. What do we want to you know, share in this context with companies hiring foreign nationals? Who wants to go first?
Well, I'll just say, you know, one of the things I'm constantly being told by the immigration attorneys who assist our clients is that you have to be really focused on which visa, because they each have their own requirements, and ensure that not only the description you put in, but the actual job itself, that there's not a dichotomy between the paperwork and the actual job work, you know, that it satisfies what the requirements are for that visa and that it's real. And I don't know if this has been borne out, but I've certainly had some clients express some paranoia that just as electronic devices might be scrutinized at re-entry into the country, they're like, you know, are they looking at my job postings? I'm like, yes, assume so. Do this right, do this real, do this honestly. Don't put in this paperwork, but then you have a job posting for the same position that's wildly different. You know, you have to be accurate and conservative and aware of what the requirements are, and if they're changing, you know, stay on top of that. And also, this is a bit of a tangent away from job description, but just back to best practices for a moment. I had spoken earlier about the importance of record keeping, that employers need to be aware of what their own internal document retention policies are and what the compliance requirements are. Are they keeping the papers that they need to for the appropriate period of time, and is it available? But along with that, I do see some of our clients, you know, they'll get their I-9 together and then they'll just put it in a drawer and forget about it. You need to keep it maintained so that if you're sponsoring an employee for a work visa or a green card, you need to make sure your I-9 records align with your immigration petitions. And if there is a change, you know, an employee gets work authorization, that you're updating the paperwork. If a worker's extends their stay, you know, does your I-9 reflect what it needs to? You don't just put it in the drawer and then forget about it.
How about, I mean, that holds true. I have a couple of I-9s in my drawer. First thing I do when I hire somebody. But that also it goes all the way down to that, you know, minute, I mean, including myself, I just updated my, or renewed is the word I'm looking for, renewed my green card. So I need to update my I-9 because I now have a different expiration date for my green card. I mean, it really goes down into the detail. And that same thing holds true for our employees. You know, if they renew their visa, you need to make sure that you have your own paperwork in order for that.
Yeah, paperwork should absolutely be updated accordingly. To touch on the job descriptions, yeah, you know, it is based on, there should be detailed job descriptions for every visa type, but particularly for the L1 category and the O1 category when filing with USCIS, they want a extent, you know, a much more detailed job description. And so, as I said, for an L1A manager or executive, what they're looking for is not just what the employee does, but how they do it and how they are overseeing people to actually do the work. So instead of them doing the actions, right, it is them delegating it to this department or this person or that person and overseeing them, conducting assessment reviews, managing targets, goals. So in every way, it is all about the nature of the role and making sure that it is in line with the type of visa that you are pursuing. And in the inverse for the L1B, it would be about that they have specialized knowledge about the company's proprietary technology and products. And we would want to see that in the job description. Additionally, we would need supporting evidence, right? So supporting emails and contracts and reports or slides of what the employee does to show that that the nature of their role really is what the visa type is aimed for.
Yeah.
Yeah.
And I want to pull in a couple of questions. One is if the address of a business within the same city changes, meaning move from 50th Street to 49th Street, do you need to amend that in the H-1B?
I believe so. I believe so. It should be updated with the address just because it may fall under a different area. But yes, it is location specific. So they should be updating addresses.
I think you're absolutely right, because my answer would have been yes too. I mean, and I'm not the immigration lawyer here, but if you just think about it, they want to be able to reach you. So for that reason alone, I think
Exactly.
yes, yeah. I mean, it's less a yes in terms of you know, wage requirements, but accessibility. Do you think having or applying for a green card will give more security than applying for an H-1B extension? You can get it.
Well, you know, unlike other immigration systems like the UK, where, you know, a non-immigrant visa quite kind of sets you up for permanent residency. The US does not work that way. Non-immigrant visas and an applicant may qualify for non-immigrant visa or for permanent green card and may not qualify for the inverse. And so often a part of our strategic advice is getting them a temporary visa so that they can work and start work as immediately as possible, as well as looking at the green card options available to them and starting both processes pretty much in tandem. So they would first, there's a caveat there. If you come here on a non-immigrant visa, you have to prove that you have non-immigrant intent. So we would wait for some time before then pursuing the green card. But you want to have your eye on both pathways and recognize that you have to be proactive about applying for both, right? And so we would discuss if that particular employee qualifies for a green card, whether that's EB2, EB1, and we would work in pursuit of that while they are currently on their work visa, their non-immigrant visa.
Yeah. And I have another interesting question about the TN visa. Can a Mexican citizen apply to a TN visa at the border? And I think the sub-question on that is, like any Mexican can work here, or what are the requirements? There must be some requirements.
Yes, so
Specialty occupation?
Yeah, it's similar to the H-1B, right? So it has to be a specialty occupation. They must have the proper qualification for the role. It has to be listed on there is like a NAFTA professionals list. So it is quite limited to that list. Yes, and they can apply at the border. So we would prepare the application for it to be processed at the port of entry. So sorry, to be clear, Canadians, it can be processed at the port of entry. For Mexican nationals, they would apply at a consulate. Sorry. So same visa, but different.
Consulate at Mexico?
Just at a consulate abroad. So
okay.
For Mexican nationals, they apply at the consulate, at a consulate abroad. For Canadian nationals, they can apply at a port of entry.
Okay, interesting. Having crossed the Mexican border, I know there's not a lot of space for paperwork. Another one, oh, we have that. We have the applying for a H-1B extension. Okay, good. We have a question. What level of risk tolerance or contingency planning is advisable? I mean, I don't think that there's any kind of risk tolerance when it comes to a visa, because if you enter the wrong way, or if you're not careful, and if you're, doing something you shouldn't be doing, you will end up in the secondary screening for the rest of your life. Not a place you want to
be. There's definitely a risk, and it depends on the foreign national's particular situation. As an example, for students go on an F1 visa who are currently on they had an F1 student visa for their undergraduate program, and now they are moving on to their master's program. If their visa, and this connects to the beginning of the conversation, if their actual visa has expired and they leave, they run the risk of not having a visa, not being able to book an interview appointment to get the new visa before they enter. So there's this risk of, depending on, especially with the current travel bans, and there was a pause specifically on interviews for F1 visas.
Right.
Now is the time where you want to speak with a U.S. immigration attorney, because we can advise on when it poses too high of a risk for you to leave if you are currently in status and can stay. But if you leave, you need a new visa to re-enter.
Yeah, very, a very good point. Any final thoughts on key takeaways? Start the process early is what I'm hearing. Don't lie
Yes.
immigration.
Yes, and I'm very willing.
Idea.
I'm willing to repeat it because I can't say it enough. Please start early. Really. Yes. Even with premium processing, with the increase in RFEs, you're still looking at about 4 to 6 months, even with the fastest track. And so that as an employer, don't overpromise, don't expect that your employee will be able to start next month or that there'll be deliverables for clients next month. If you are not aware of the process and how long the current processing time will take.
Did you just say 46 months?
4 to 6.
Oh.
Sorry.
I'm like, oh, good Lord.
And those are for the non-immigrant visas. And that is, you know, fastest route if you think about the preparation and the filing and the possibility for an RFE before the employee actually gets the visa so they can come and work.
I have a question, Dina, final takeaways?
Stay on top of deadlines. Technology is our friend. It's a complicated world and we all have a lot on our minds. So get those alerts, those reminders electronically to help you and your team not to miss a deadline and to, as we've said it 18 times now, start early.
Yeah, very good. And do hire an immigration lawyer.
And
Don't
hire,
do it yourself.
speed dial.
Yeah.
Immigration
Although
lawyer.
I have to say, I did the green card renewal myself because I talked to an immigration lawyer. My immigration lawyer, and he said you can do it yourself. Just go online, check. And that was true, but not for the first time we did it. So I just did it for the last renewal.
Yeah, no, there are definitely some processes that are quite simple, like F1 student visas, you know, unless there is a complication such as criminal history, right? That would make it a bit more complicated. If you have quite a simple case and it is a category that is quite simple, we would say the same thing. We would advise when clients could do the applications themselves.
Yeah. No criminal record here, and I'm not planning to have one. So easy peasy.
Good. We like to hear that.
Very good, Kensani and Dina. Super nice to have you with us.
Thank you for
so
having
much.
us. It's been quite a pleasure. Thank you.
Thank you for joining us for this program. If anybody who's been on the following this webinar, please do reach out if you want to, if you have additional questions for either one of our experts here today. And with that, we're at the end of our session today. Thank you, everybody. And we will have a recording of this webinar on our YouTube channel, and we'll probably load it up tomorrow, early tomorrow. And we have a couple of really interesting programs in the pipeline. We are going to showcase a transatlantic expansion barometer on July 8th. We have a program on M&A deals and valuations in September, and a economic outlook with a number of chief economists also in September. So stay tuned. We have a couple of private events coming up as well. Go to the website, and we'll see you soon. Thanks, everybody.
Thank you for having us.